मराठी असे आमुची मायबोली अमृतासी पैजा जिंके असं आपण नेहमीच म्हणतो, म्हणून मी मराठीतून सुरुवात करतो आहे. मला वाटतं आजच्या या समारंभासाठी इतकी सुंदर भाषा महाराष्ट्रात असल्यामुळे आपण सुरुवात करतो. मी वरुणजीकर साहेबांचा फॉलोअर आहे आणि आजच्या समारंभाचे प्रमुख पाहुणे ऑनरेबल जस्टिस श्री तावडे साहेब. सर, तुम्ही सुरुवातीलाच आम्हाला एक प्रश्नमंजुषा दिली आणि वी आर रिअली थँकफुल. मला वाटतं हा पहिलंच पुष्प आहे वाविकर लेक्चर सिरीजचं 5वं, तिथे आम्हाला खूपच आमचं भाग्य आहे की तावडे साहेब स्वतः इथे आलेले आहेत. त्यांची कमिटमेंट, त्यांची सिम्प्लिसिटी आणि अप्रोच आम्हाला खात्री आहे की कंझ्युमर जस्टिसला आणि कोर्टानंसुद्धा एक नवी दिशा देऊन जाईल. त्याचप्रमाणे आजच्या आमच्या इथे समारंभात उपस्थित असलेल्या लीगल रजिस्ट्रार भोसले मॅडम, आमच्याकडे आज ह्युमन राईट जस्टिस फॉर ह्युमन राईट्सचे जे संचालक आहेत सगळे, ते ॲडव्होकेट भीमानीसुद्धा प्रेझेंट आहे. आणि अजून एक अशी व्यक्ती इथे प्रेझेंट आहे जिने हे संपूर्ण माझं आयुष्य फ्रॉम अ कॉर्पोरेट एक्झिक्युटिव्ह टू अ लीगल प्रोफेशन बदललं आणि त्यांच्या हाताखाली मी तयार झालो. असे माझे सिनियर अशोक शेट्टी आज इथे प्रेझेंट आहेत आशीर्वाद द्यायला. आजचा जो कार्यक्रम हा झाला हा केवळ मेहनतीमुळे झाला. मी म्हणेल मुसीबतें चाहे कितनी भी हो, कंज्यूमर कोर्ट बार एसोसिएशन की श्रद्धा कम नहीं होती, जैसे करो सोने के 100 तुकडे उसकी कीमत कम नहीं होती. की हा एक यज्ञ आम्ही चालू केलेला आहे या व्याख्यानमाले, माझ्या पिताश्री आणि मातोश्रींच्या व्याख्यानमालेच्या दरम्यानी. आणि नवीन ज्या वेळेला कायद्यात बदल होतात त्यावेळेला त्याच्यावरचं मार्गदर्शकपर व्याख्यानमाला सुरू असते. मला यज्ञ याच्याकरता म्हटलं आहे की जस्टिस धर्माधिकारीने एकदा म्हटलं होतं की कित्येक समारंभात आपण एवढे बल्ब असताना ज्योतींनी पेटवून सुरुवात करतो, तर त्यापेक्षा का करतो, कारण ज्योत से ज्योत जलाई जा सकते, बल्ब से बल्ब नहीं जलाया जा सकता. परंतु आज आपण ज्ञानाची ज्योत प्रज्वलित करतो आहोत आणि म्हणून त्याने म्हटलं आहे की जब ज्योत से ज्योत जलाई जाती है तब, क्योंकि बल्ब से बल्ब नहीं जलता, क्योंकि बल्ब एक विज्ञान का प्रकाश है. जब ज्ञान की ज्योत का प्रकाश आता है तो विज्ञान का प्रकाश तो आता ही रहेगा. हे उदय प्रकाश वरुणजीकरांनी आज हा यज्ञ सुरू केला आहे. थँक्यू सर. आणि जोरदार टाळ्यांनी आपण CCAच्या सर्व सहकाऱ्यांना आपण त्यांना मानवंदना देऊन चांगला कार्यक्रम सुरू केलेला आहे. म्हणून आजच्या विषयाविषयी बोलायचं झालं तर मी आज खूपच डिटेलमध्ये बोलीन आणि ते म्हणजे महत्त्वाची गोष्ट म्हणजे आज आपण बघणार आहोत 2 ॲक्ट 25 आणि 27चं कंपॅरेटिव्ह स्टडी आणि त्याचप्रमाणे प्रॅक्टिकल आस्पेक्ट्स ऑफ दिस ॲक्ट. हे पुढल्या पुष्पांमध्ये माझे सहकारी आणि कलीग मोहित बन्साली करणार आहेत, त्यामुळे तो पार्ट मी जास्त टच नाही करणार आहे. परंतु तुम्हाला एक विनंती आहे की तुम्हाला काहीही प्रश्न असतील तर ते प्रश्न शेवटी विचारा. तुमच्या प्रश्नांना ॲडिक्वेट वेळ देऊ, प्रेझेंटेशन वेळेवर संपू. आणि त्याचप्रमाणे मला माहिती आहे आपल्यातले बरेचसे लोक बार असोसिएशनचं लेक्चर घ्यायला जायचं आहे त्यांना 6 वाजता, त्यांचेसुद्धा वेळेवर करू. परंतु तुमचे प्रश्न मात्र ऑब्जेक्टिव्ह ठेवा आणि ते तयार ठेवा, म्हणजे पटपट आपल्याला ते क्वेश्चन आन्सर्स करता येतील. बहुतेक तुमचे प्रश्न प्रेझेंटेशनमध्ये येतील. तर आजची सुरुवात करायची झाली एक्झिक्युशन. आता execution order passed by the Honorable District State National Commission can be done under the following sections of Consumer Protection Act, Section 71 and 72. Now next, Section 71 and 72 ह्याच्याच खाली का आणि 25-27 खाली का नाही, कंपॅरेटिव्ह स्टडीमध्ये मोहित आन्सर करतील. पण त्याला एक नॅशनल कमिशनचं जजमेंट आहे आणि आय विल कम टू दॅट जजमेंट. What about the orders of the complaint filed decided under the old Consumer Protection Act 1986, under which the sections we can be filed under for the execution? कन्फ्युजन असं होतं की जर तुम्ही कंप्लेंट ओल्ड ॲक्ट खाली असेल तर अपील फाईल करताना इट विल गो अंडर ओल्ड ॲक्ट, डिपॉझिट विल बी ॲज पर द ओल्ड ॲक्ट. Section 107 of Consumer Protection Act says that it will relate back in terms of General Clauses Act 6, Section 6. And therefore all those complaints which are filed prior to the amendment of the act will remain with that respective court and they will not be transferred to the respective down court or upward court, whatever. So therefore whether that section will apply here or not was a controversy. Why not file under 25 and 27 was another controversy. Both these controversies are answered by the judgment, latest judgment of the National Commission. I will give you the citations and this link. Please do not note down. Listen, that is more important. as per the order passed by the Honorable National Commission in Amit Agarwal versus Sri Vardhaman Infra Home Private Limited, having execution application of 99 of 2020, dated 25/4/2022, it has been held, and this is the most important part, that the execution proceedings are a separate independent proceedings. This is very important part, and in view of the fact that there are separate independent proceedings for execution of decree, therefore it has to be filed under the act which has been prevalent at the time of filing of the execution proceeding. It makes it very clear that you don't have to go to 25/27. Of course, my learned friend will come with the next Jugalbandi at that time. I know, but this has been at least resolved by this administrative order or a precedent that is there of the National Commission today, which means now we have to file all the execution applications under 71 and 72 of the new act and not under section 25 and 27 of the old act. Clear? Now let us go to the next, because I am raising certain issues and focusing. We have a limited time today. Execution application can be filed to execute any order of the Honorable District, State or a National Commission, either interim order or a final order. Lot of time question comes whether an interim order can come under the execution. That is the beauty of the Consumer Act, that even the interim order we can go for an execution and it is applicable absolutely. Section 71. This is a new section altogether where the order 21 has been now introduced. In view of the fact that order 21 has been introduced, the order 21 is so vast that one can reopen the whole case. Those who are practicing here on civil side, and let me tell you, we have our past president Patwardhan, we have Manna DR here, solicitor, we have so many civil court lawyers present here, including you, sir. You will be, the Tate is there, you will be helping us on the questions of 21. You are not supposed to ask questions, you are supposed to answer them. So you will be the guiding factor, but we will come to that. As far as the latest position is concerned, the first, that is, let us go here. If it were a decree made by the court in a suit before it, and the provisions of order 21 of the first schedule to the Code of Civil Procedure 1908 shall, as far as possible, may be applicable, subject to modification, that every reference therein to the decree shall be constructed with reference to the order made under this act. The last line is very important. Therefore, the whole schedule of 21 and the orders of 21 will not be applicable. Only the orders which are pertaining to the order, that is the executing decree, and the act, that is the Consumer Act, with the reference to Consumer Act, which are for the compliance of the order of the Consumer Act, the section 21, order 21 will be applicable. Very clear, because otherwise people start raising lot of issues on this point and they go beyond the decree, they try to reopen the case, and that's not allowable, because ultimately in any execution it's a common principle that you cannot go beyond the decree. And when entire matter has been decided by Supreme Court, the order has come back after becoming final. If you start again doing a procedure under 21, order 21, which is not in compliance with the object of the act, then definitely it will create a problem. So let us go further. Procedure for section 21 of the Consumer Protection Act 2019 and the rules of order of 22 of CPC, which attracts the execution process by consumer court. The decree holder has to make an application in the commission passed with the order. I am not going to go with this basic rules for the simple reason all of us are filing, yet for in the quickly minute we will see. Under our rule 10, we have to file an application for execution under 71, which is under order 21. The decree holder is required to give full disclosure of the property which has to be attached to satisfy the decree under order 21, rule 12 and 13. After receiving the application of execution of order, the commission verifies whether the applicant has complied all the requirements given under rule 11 and 14, and only upon all the compliances made by applicant, the commission admits the said execution application as per the order 21, rule 70. Very clear, crystal clear. For admitting the said application, the commission issues notice the judgment debtor as to why the decree should be executed against him, order 21, rule 22. I think I am clear. Please note down. If you have any questions, you can note down. Next. In case the applicant is unaware of the property held by the judgment debtor, this is very important, then the applicant can make application under Order 21 Rule 41, which give powers to the Commission to orally examine as to whether any or what debts are owing to the judgment debtor and whether the judgment debtor has any or what other property or means of satisfying the decree. The court may make an order for attendance and examination of such judgment debtor or officer or a person and for production of any books or document. All of us, those who are regularly practicing on civil side as well as under the Consumer Act, knows that the Consumer Court can enforce any document, can search, fine, ask for the custody of the documents and the books and documents. Therefore, this order helps a lot wherever we do not know what is the property or otherwise. Rule 41 really helps a lot. In case of disobedience of any order made under Rule 41, the Commission may direct that person disobeying the order be detained in the civil prison for term not exceeding 3 months unless before the expiry of such the court directs his release. Such a stringent provision is also available under 71 for non-compliance of the order under Rule 41. After getting all the details of the properties of the judgment debtor, the Commission proceeds with the attachment of the movable as well as immovable property of the judgment and the debtor to satisfy the order decree. The Consumer Court has a power to direct the bailiff to attach the properties of the judgment debtor, and the property attached is kept in the custody of either bailiff or the Commission. Now question is, you will all ask me, where is the bailiff in Consumer Court? We have found out a very unique procedure here now by practice, and of course I will be thankful to Justice Tavde for that, that advocates are appointed as a commissioner to attach the properties, and they are doing very well. I think one of the advocate, Gawan, is present here, he's been regularly doing it. So many of us are doing it now. So that is the answer, but we are looking forward to the government to provide us the machinery of bailiffs so that tomorrow this can be really effective in terms of attachment of the properties. What is the key is, what we really miss is the second part of this, and that is attaching immovable property. I remember when one of the worst, one of the famous person I will not name, when he was not at all getting caught by the police station, the attachment of the properties, especially immovable properties of the flat, when the properties came down, the TV, fridge, etc., he immediately came because his wife and everybody started annoying him, and he came down and complied the order. So therefore, attaching immovable property is also very important. We don't look at that aspect generally. After getting all the details of the property, judgment debtor and commission proceeds with the attachment of the movable as well as the immovable. Next slide. So therefore, immovable property is very important to be attached. Difficulties and limitation of attachment of properties by the Consumer Court. As we discussed, Consumer Court today does not have bailiff, and therefore the Consumer Courts can appoint any fit person as a bailiff to attach the properties. That provision is also there. Next, in case of judgment debtor, if he fails to satisfy the order, then the Commission have powers to sell, auction, attach properties under Order 22 Rule 64, which is as under: any court executing a decree may order that any property attached by it and liable to sell or such portion thereof as may see necessary to satisfy decree shall be sold, and then the proceeds of such sale or a sufficient portion thereof shall be paid to the party entitled under the decree to receive the same. So they can be auctioned, proceeds can be collected, and they can be, this is a unique power which Consumer Courts have, and I am sure we have been joined by Mr. Sampath also. So he also is endorsing this, and therefore wherever, next, in case of where the order is for handing over the possession or any immovable property, the judgment holder, then the Order 21 Rule 35 gives power to the courts to take a forceful possession of the said immovable property after giving a sufficient opportunity to a person who is in possession and hand over the possession of the judgment holder. Recently, in one of my case, such a thing has been done by Honorable Justice Tavde and the bench. The flat concern which was bought by the complainant, that is the purchaser, was occupied by one of the person of the builders. That property was attached, he was taken out from the custody. Property, that particular flat is handed over to the complainant, and I think it's a unique achievement, because getting your own flat which builder's person has been staying there is a very difficult process, but that was achieved. And I think this is a wonderful thing that Consumer Court has powers now given under Order 21. Let us now go to the property of the judgment debtor is already attached by any other court. Now this is again unique. People say matter is in the High Court, sir, matter is here, matter is there, therefore we cannot touch. The property of the judgment of debtor is already attached by any other court. Then the Order 21 Rule 52 gives powers to the Commission as follows. Where the property to be attached is in custody of any court, public officer, the attachment shall be made by the notice to such court or officer requesting such property, and any interest or undivided becoming payable thereon may be held subject to the further orders of the court from which the notice is issued. We have found, these are unique cases happening in district forums. We have found that there are 4 buyers of the flat who gets a decree. They go for attachment and they start auctioning the entire property of that builder. And then we find at the same time 70 complaints are pending. Justice Bangale, in such one of the case of ours, stopped that collector auction by requesting and then sending the matter to Honorable High Court also, but stopped that auction at that moment, and that auction was delayed, and then it was decided whether the possession could be given or not. By that order was stopping the auction by the collector. The flats are today given in the possession to the people, because the other 70 decree holders were also waiting, and therefore that was stopped in a right perspective of the Consumer Act. So such thing is allowed now under order. We can request that court, it's a senior court like High Court or otherwise supervisory courts also, to wait, and proper justice can be given, equitable justice can be given. So let us go further. Rule 52 is very important from that point of view. Next. Now this Order 21 Rule 32 gives a power to the Consumer Court to appoint registrar to sign a conveyance deed. Sir, this is a very unique power, and you have used it, I know, under the case that is famous now, allowed by the Supreme Court. That is, I think, Agarwal's case, where we have quoted that also. Kamlesh Agarwal, yes. What has happened is, in this case, where the people do not come forward to sign conveyance, or they become as an obstructionist. The landlord doesn't come, he wants more money, or the other people do not come. Then what happens? Then the Consumer Court Registrar Madam is now given power to sign the conveyance deed of such obstructing party, which is unique, like deemed conveyance, but here we do it under execution. And that power has been now given by Supreme Court to the Consumer Courts, and thereby my own father's society, where the flat was my father's flat, Sri Balchandra Wavikar's flat, there the conveyance was not getting done, the landlord was not cooperating for obvious reasons, and the order was passed that the registrar should sign that, and accordingly registrars have executed conveyance deed in absence of the landlord by specific order, and that conveyance deed is registered now, property name on the card is changed. And this is as per the Kamlesh Agarwal versus Narayan Singh Dabas, having civil appeal number 224 of 225 in 2015, dated 10/2/2015, directed the registrar of the district commission to sign and execute the conveyance deed on behalf of the builder developer wherever the opposite parties were non-cooperation or obstructing. If the builder does not come, if the landlord does not come, our state commission and the foras and national commission, of course, are fully now equipped that the registrar can take over and sign for obstructing parties the conveyance deed, so that the properties can be transferred. A very, very unique feature which has now come. Next. Section 72. So here we end with the procedural aspect of section 71. Now the important section of 72, which is not much change compared to 27. There are few changes in terms of amount, but procedure wise there are not much changes. Whoever fails to comply, this is a big deterrent, because consumer courts have sent 7 builders at the last occasion, which I have seen, through the state commission to the jail for rigorous imprisonment of 3 years for non-fulfilling the order of conveyance also. Whoever fails to comply with any order made by district commission or state commission or national commission, as the case may be, shall be punishable with the imprisonment for a term which shall not be less than 1 month. This is now changed. We shall not be less than 1 month, but which may be extended to 3 years with a fine. Now this fine is also changed. Fine which shall not be less than 25,000 rupees, but which may be extended to 1 lakh rupees or with both. This is a powerful deterrent which we have got under CRPC under section 72. Next. Notwithstanding anything contained in the Code of Criminal Procedure 1973, the District Commission or the State Commission or National Commission, as the case may be, shall have the power of judicial magistrate of first class. Can you imagine the President of the Consumer Court has a judicial power of first class judicial magistrate, and this is a very unique feature of Consumer Act to act upon. Even the Prime Minister will have to appear before him or her. So that is the kind of first class judicial magistrate powers. Commission, the National Commission, as the case may be, shall have the powers of judicial magistrate first class for the trial of offences under subsection 1, and on confinement of such powers, the District Commission of State Commission or National Commission, as the case may be, shall be deemed to be judicial magistrate of first class for the purposes of the Code of Criminal Procedure 1973. I think Mohit will also explain, under the old Act there was a conferring of the powers, and therefore the difficulty is to come. Now that is automatically given under this Act, and there is no need of conferment of powers, save as otherwise provided powers by the Maharashtra State Government. Save otherwise provided the offences under subsection 1 shall be tried summarily by District Commission and State Commission and the National Commission, as the case may be. Most of you know the summary proceedings. I am not going to go on the features of summary proceedings, but we are going to see the salient features. The procedure under 72 of Consumer Protection 2019, the Commission is bound to execute a decree to take a penal action against the respondents by following up the procedure under section 262 chapter 20 and section 251 of the Code of Criminal Procedure in accordance with the law. The decree holder has to make an application to the Commission which passed the order. Next, you have to go before the same court for passing the order. Since all of you are lawyer, I am not going into nitty-gritties of explaining the sections. You are all aware of this. You are practicing day in and day out. After receiving application under section 72 of Commission issues summons to the accused, respondent through concerned police station. Now here I am just pausing, sir, for a moment, that some of the presidents of the forum issue a notice under civil law for compliance of the order. That notice is generally already given by the advocates, and then summons are not issued. That is not correct by my opinion. I think Patwardhan will also agree with that, and therefore we will have to give a summons only, because next is the bail procedure. Application Commission is to summons to the respondent concerned police station. In case the accused and respondent files the appear before the Honorable Commission, then the Commission issues bailable warrant to compel the presence of the accused and respondent. If the accused respondent fails to appear even after serving the bailable warrant, then Commission issues non-bailable. Now there is another question, we will come to that next. Once the accused respondent appears before the Honorable Commission, then the following procedure is to be followed by the accused and respondent. The accused respondent is to make a bail application. If the bail is granted to the accused, then accused is bound to execute personal bond of surety bond or any sum fixed by the cash bail, that is by the Commission. The accused can either give cash surety or solvent surety as directed by the Honorable Commission. In case the accused to bring the solvent surety, then the accused can be released by executing personal bond, and Honorable Commission gives specific time to execute surety bond before the next date of hearing. I think most of us are aware of this procedure. I am just taking a quick brief on this. Once the bail procedure is completed, then the court can start trial under the following proceedings. Section 251 of Order 20, substance of the accusation to be stated. When a common case accused appears is brought by the magistrate, the particulars of the offence of which he is accused shall be stated by him. Then he shall be asked whether pleads guilty or not guilty. We are talking of recording of plea also many times. Guilty has any defence to make, but shall not be necessary to frame the formal charge. If there are any questions, please ask afterwards. Next is, if accused pleads guilty, then he can be convinced and punished in the section 72 of Consumer Protection Act 2019. If the accused pleads not guilty, then Commission has to record evidence under section 262 of CRPC, which states as under: every case tried summarily in which the accused does not plead guilty, magistrate shall record the substance of the evidence and the judgment containing the brief statement of reasons for the finding. If the accused does not plead guilty or claims that he has a defence to make, the District Forum, State Commission or National Commission as may be shall record the substance of such evidence as may be produced by the complainant. The evidence may be oral, documentary, in his discretion, complainant may seek to rely on solely upon the order passed by the district forum, state commission and national commission as the case may be, and in such case the aforesaid order would constitute evidence produced by the complainant. This particular provision reduces all the further detailed examination chief and cross examination, or even filing, giving an affidavit and then crossing him, taking the examination in chief, because it is the order itself becomes the base of your evidence. And this is a unique provision which has come now. Next, if oral evidence or evidence of affidavit is given by the complainant, the accused would be entitled to examine the deponent, which, since the evidence as defined under section 3 with section 138 and 139 of Evidence Act comprises not only examination in chief but also the this is how it is shortened up, also the re-examination, if any, permitted by the court, and evidence in criminal trial without an opportunity to opposite party to cross-examine the witness will not constitute legally admissible evidence. This cross-examination of witness being fundamental and indefeasible right of the accused. So therefore, cross-examination is also very important. It cannot be just ignored like that. If the oral evidence or the evidence of affidavit is given by the complainant, this is what we have just seen, and therefore cross is also essential for natural justice, but that cross has to be limited to the decree and nothing beyond decree, because otherwise the cross, how long we take and what happens. So this is a beauty, but one has to be aware that the substance of the evidence has to relate to the order and not beyond the order. That is because already it is decided by the consumer court. Trial, this is not trial. That is the difference between trial and execution proceeding before the consumer court. People ask 3 years imprisonment has to have a trial. Consumer Act is an exception to it. 3 years imprisonment, you do not require the entire trial to be conducted, if it is not necessary. If oral evidence or evidence on the affidavit is given by the complainant, the accused would be entitled to cross-examine the deposit witness, since the evidence as defined under section 3, section 138 and 139. We have seen this now. Let us go to the next slide. And therefore, section 313 of CRPC gives powers to the Honorable Commission to examine the accused in every inquiry or trial for the purpose of enabling the accused personally to explain any circumstances appearing in evidence against him. The court shall, after witness for the prosecution have been examined and before he is called for his defense in question him generally on the case. This is very important provision. If you have any questions, I will definitely answer. We will try to answer you. But this is the right of the accused also, which takes again to the principle of natural justice. Next, after examining the accused in terms of section 313 of CRPC, except 313 statement I am talking about now, except where such an examination is dispensed with, the district forum, state commission or national commission as the case may be, is required to take such evidence as the accused may seek produce his evidence, or accused however, now this is very important, cannot be allowed to lead evidence which is not strictly relevant to the proceedings initiated. This is the heart of the consumer execution. You can't just go beyond the proceedings of the consumer court and the order, because that is the final Bible. Accused, however, cannot be allowed to lead evidence which is not strictly relevant to the proceedings initiated against the under section 72 of CP Act, and only the evidence can be allowed to be produced by him as would prove legal defense to the proceedings initiated against him under section 72 of this Act. This is the heart. You have to restrict to the order and not go beyond the order or the proceedings in the consumer court. Next, it will always be open to the district forum, state commission to national commission as the case may be, to disallow such evidence sought to be produced by the accused as is found it is irrelevant, frivolous or aimed for prolonging the trial. This is the art, and that has to be done. Most of the time it does not happen in forum with due respect, but that has to be done, and therefore we have to see as an advocates that the trial is speedy. So by showing this provision of defeating prolonging the trial, thereby defeating the mandate of the Act, which envisages a summary trial of such offences. The complainant, of course, would be entitled to cross-examine the witness of the accused, including those whose affidavits are filed by him by way of evidence, if the accused decides to enter witness box in terms of section 315 of CRPC the complainant shall be entitled to cross-examine such an accused. This is also a provision which gives the complainant power even to reconsider if he is trying to get away from the order. It will always be open to district forum, state commission or national commission, as the case may be, to allow such evidence sought to be produced by the accused as is found irrelevant or frivolous. We have seen this. Next slide. And therefore, you are very clear that everything has to be related to the order and final order now. After recording of the substance of the evidence, the complainant, examination of the accused, the defense evidence if any, the district forum, state commission or the national commission, as the case may be, shall deliver the judgment which needs to contain only brief statement of reasons for findings recorded by. Very brief order. Next. In case the commission passes final order against the accused, convicting him under section 72 of Consumer Protection Act, the accused can file an appeal under section 73 of Consumer Protection Act against the final order under section 72 of higher court before filing an appeal before higher court, and the accused has to make an application for suspension of sentence till the statutory period of filing the appeal. So it will be only till the statutory period of filing the appeal. What is the period of filing the appeal? Anybody? 1 month. That's correct. Under execution 1 month, 73. So therefore, the suspension can be only for a month and nothing beyond it. The accused has to make application for bail in the appeal filed as under section 73, and then only the procedure of the appeal gets started. Therefore, friends, I have taken you very quickly with the entire procedure of 71 and 72. Yes, please. What is your good name?
Sir, my name is Adv Uday Wavikar. I have argued alongside my
Yeah, tell me.
Sir, in the civil execution, particularly in the execution where deeds are required, conveyance deed, cancellation deed, etc., when we take the order or decree to the sub-registrar for registration, we have to register the conveyance deed or cancellation deed. Is the officer of the learned consumer courts also required to appear as the sub-registrar?
No. If you see the deemed conveyance provision, I like our execution provisions, the registrar, once he signs the conveyance deed for the obstructing party, he does not have to go as an officer of the court to the sub-registrar's office.
Wonderful.
That's a wonderful thing.
Yes.
And of course, we have Sampath present here maybe, and he knows thoroughly well in the case of registration, not required. And I have done such a thing. I am talking after doing it. Yeah, he is exempted. You are absolutely right. Under I don't remember the section at the moment. Under the Registration Act, the registrar of the consumer court is also exempted. Likewise, the cooperative court registrar to appear before the.
What is the time limit for the deciding that execution?
Under the criminal court or under the order 21?
Order 21.
There is no limit. 12 years, of course, is allowed. But is there any limit, Anand? I don't think so. There is no limit. In consumer, there is no limit in filing, according to us. That question is not decided yet. But as far as today, what is the limit according to you under General Clauses Act? 12 years. Okay. Ultimately, 12 years is enough time.
There is no limitation provided. Supreme Court direct judgment talks about CPC 12 years period for execution of decree, consumer no period. Even after 12 years you can get it.
I think Mohit will share that judgment with us, and it's a direct Supreme Court judgment, so you don't have to worry. Next.
In the criminal execution, whether notice which is first sent to the accused, whether that counts as a bailable warrant or subsequently another bailable warrant will have to be issued?
No. That is only for compliance notice we send. That can. Sorry. Advocate Nagaraj is here, president of the Thana Bar, who was working with Advocate Dighe in the criminal procedure code for a long time. Yes, Nagaraj, bolo. The notice itself is a summons. If you send the compliance notice, summons will be issued. I am really thankful to you all, and I will only say that still second part, ये तो picture तो अभी बाकी है दोस्त, ये तो trial था. So second part is coming. Let us wait for second part of Mohit, because Mohit is very dynamic and at times he likes to be controversial. He was telling me yesterday in George Bernard Shaw in Great Britain raised a controversy saying that Shakespeare was not one man. It was different people who wrote Shakespeare. and there was such a fever. Nobody had opened the books of Shakespeare dramas. Everybody opened the book, read Othello, read this, read that, criticized Bernard Shaw. Ultimately, after 2 months, Bernard Shaw wrote, I knew he was a one person, because since you were not reading, I wanted you to read, open and read. Therefore, the controversy stops here. So let us now look at the 21st lecture. I would only end up by saying, which is my favorite quotation for all the lawyers, specifically CCA and the consumer court litigants, that कहते हैं कि बात ही बात में विश्वास बदल जाता है. बिल्डर से फ्लैट लो, मिलता ही नहीं, विश्वास बदल जाता है. रात ही रात में इतिहास बदल जाता है, बेच देता है. पर तू मुसीबत से ज़रा घबरा, एक कंज्यूमर कोर्ट के वकील, ग्राहक और लिटिगेंट, अगर तू चाहे धरती तो क्या आकाश बदल सकता है. Let us wind up. Jai Hind, Jai Maharashtra. Thank you very much.